Okay. Okay, that's some of her police interview. We have to talk about it now. And joining me on Special Monday, I think she always comes here on Mondays, and I'm so happy for it. It's a great way to start the week. Law&Crime trial analyst Jonna Spilbor. Jonna, great to see you.
Jesse, good morning.
Good morning. Now, what we saw last week in the Shayna Hubers case is a psychologist took the stand and said that in his opinion, Shayna Hubers may suffer from PTSD and borderline personality disorder. Do you think that's what we're seeing a little bit in that police interview? And let's not forget, the psychologist said that even if she suffers from that, and even if that explains her behavior in that interview, the insanity defense doesn't work for her because she knew what she was doing. What do you make of this from a legal perspective?
So, well, by taking the insanity defense off the table, because it really doesn't apply here, we're not going to be looking at a not guilty verdict on those grounds. And I may venture to say we probably aren't looking at a not guilty verdict anyway, because there is something, when you watch her affect, her mannerisms, the way she describes what happened, to me, there is something off. Now, I'm not a shrink, I'm a lawyer, and, you know, over the last 25 years, I've seen some people who displayed some off personality traits, and there's something there. And I think what the defense can hope to do with her PTSD and the other things that are affecting her psychology is to minimize, perhaps, the impact of what she did, as opposed to completely get an acquittal, even though her defense here is self-defense, which would lead to an acquittal. I'm not so sure she's helping herself with her testimony or the psychiatrist's testimony.
And that's where that brings me next. Does it help that she took the stand? Because that's what we're going to play you right now. This is when Shayna Hubers, the defendant herself, took the stand and explained what happened the night she shot Ryan. Take a look. Wow. Pretty incredible when you get the defendant to take the stand, let alone Shayna Hubers. Let's talk about it with Jonna. Jonna, she's providing a lot of detail. Now, in your experience, easy, Jonna.
Oh, sorry.
Easy.
Oh, God.
When somebody takes the stand and provides that level of detail, is that good? Is that saying, hey, this must be true? Or is that, hey, they're making up a lot of details here just to embellish the story? What do you think of that?
I have a couple of thoughts on that. When somebody provides too much detail, and I think even if you quizzed FBI agents who interrogate people for a living, too much detail is a problem. Too much detail is usually an indication, excuse me, that the person is lying or embellishing, or that they've created a story that they needed to convince themselves. They go over and over and over the facts, and then they try to regurgitate them to you. But it also is a sign to me that people who do that, people who either decide to embellish or lie, there is something off. There's something off mentally, as I said before. And I said to you while we were watching that clip, she has shades of Jodi Arias. And Jodi Arias took the stand for something like, I don't know, 17 days. It was some god-awful amount of time. It didn't really work for her either. And there are shades there. She's trying to, can I just ask, what does her sex life have to do with self-defense?
Okay, I'll play devil's advocate. Okay. If you take the picture of her as somebody who was sexually and violently abused, and you take that person and put them in that situation, could you say to the jury, think about what might have happened to that woman? Think about all the circumstances surrounding that, and perhaps she really did feel her life was in danger. Is that a way to articulate it?
It doesn't fly with me, and here's why. It's not as if she's claiming this was, you know, a horrible potential rape situation, which would make her brain go in a direction. She's basically saying she went over there for dinner. He said, you know, you're not right, and tried to carry her out of the house. And the next thing you know, he's dead. She's not. Self-defense is not. She's not doing herself a favor right now.
And we talked about it earlier that the insanity defense wouldn't have worked for her, that she knew what she was doing. So her only avenue really is self-defense. And that's what we're going to talk about when we get back, because we are going to continue playing you more of Shayna Hubers on the stand. Stay tuned. There you go. Defendant admitting it and explaining that she had no choice but to shoot Ryan Poston. Let's bring back in Jonna Spilbor to talk more about it. What, in your mind, because we were talking so much about the critical aspect of her testimony, what would she have had to say on the stand in order for, in maybe your mind, Jonna, to be a little bit more convincing?
I guess if I'm a juror, I want to hear that the gun was pointed at her, that he, you know, exclaimed, if we believe her, that he was going to kill her, and that he took a step in that direction. Other than, even if she's trying to be truthful here, this is all in her mind. Like, she's not setting a scene that her life was in imminent danger of great bodily injury or death. She's just simply not doing that.
I suppose you can say that also because when you look at her crime scene photo, when you look at her mugshot, she has no injuries on her. And there was no evidence of a struggle.
No evidence of a struggle.
This is not a woman who, when she's being interviewed by police, she doesn't have bruises all over her face. It's not like you would see in another situation. If she was beat and battered, maybe you're saying that would be more convincing. Then again, every level of struggle could be different. Maybe she really was in a struggle and there's just no physical signs of it.
You know, but her belief has to be reasonable. And she said a couple of little nuggets so far that really give me pause as a person, as a lawyer, and if I were in the jury box. He's trying to carry her out of the house. Like, this was a relationship, to me, this is the scenario she's painting, that went bad. She didn't want it to go bad. The prosecution has basically claimed she shot him in a jealous rage because he was going to leave her. And she gave us testimony that actually helps the prosecution's theory. I'm almost feeling sorry for her defense counsel at this point. They're being very, timid almost with their questions. They're a straight up direct examination. They're not going in. They're not asking to embellish, just question to question, almost as if they themselves don't believe her.
I want to give our viewers an update. The defense has just rested in the Shayna Hubers case, and now they are putting on their rebuttal case, their rebuttal witnesses. As you know, there's no live feed in the courtroom, but we will update you more. I want to play the testimony of Holly Nivens, her cellmate, because some of her testimony doesn't contradicts with what Holly had to say. Take a look. Wow, that is not a self-defense claim. That is not, Jonna, that is a big accusation thrown there that Shayna Hubers is making this entire self-defense story up. What do you think?
Will the jury believe this witness? You know what I found ironic? This witness started to cry during her testimony. She hasn't killed anyone. But the defendant, so far, not a tear.
The most outrageous part, that how could it's so outrageous, how could it not be true, is she said that Shayna told her that Ryan's family has enough money that they could buy a new child. How could someone realistically make that up? It has to be true, right?
That is so outrageous that you would think it was heard properly. Who would sell you? Who would buy another you, Jesse?
I am not for sale. No. But I'll tell you what's interesting is this is just the tidbit of the top of it, the Shayna Hubers case. We have a lot more when we come back. Okay, that was some of the testimony of Doris West, a neighbor of Ryan Poston, who was there the night that he was shot and killed. Want to bring back in, Jonna Spilbor to talk more about this. Testimony from someone else who is not right in the apartment, but was right there. This isn't like it happened in a remote field. It happened in an apartment complex.
Well, yes, and she does appear to be a credible witness. She's this, if I dare say, sweet little old lady neighbor. But we already know, nobody's disputing that a shot went, or that a gun was fired. Nobody's disputing that. So that doesn't really help the prosecution's case all that much. I think she also, it was hard to hear, but she also testified that she might have heard, I don't know, some sort of argument or discussion. And it's interesting, though, because this is actually testimony from the first trial, but since this witness is unavailable in this trial, that's why they're playing this now.
And I want to talk about this. This trial is a lot different than Shayna Hubers' first trial where she was convicted. Why? In your opinion, what is so different about this trial? We've seen a lot of commentary about it being so different. What do you think makes it so different?
Well, for starters, I don't believe Shayna testified at her first trial, which is the biggest difference, obviously. So, to that end. And in the first trial, look, I think it's kind of unusual that the appellate court granted a new trial for jury misconduct when the misconduct was that a juror had failed to disclose a prior felony. You would almost think a fellow felon would be a little sympathetic to Shayna, but she was convicted anyway. That's always struck me.
Now, we haven't heard anything about the sexual abuse in the first trial. She didn't take the stand in the first trial.
And that's why you didn't hear about the sexual abuse.
What's the strategy for the defense? They're obviously doing something different.
Well, I guess they're trying to make Shayna a sympathetic character. They're trying to find a legal excuse for why she would think her life was in danger ergo the self-defense defense. And this is the best they can do. I am just not so sure. Maybe I'm reading too much into the defense attorney's lack of enthusiasm with his direct examination of her. I could be reading into that. I'm not so sure she sold her story to defense counsel, but defense counsel, unless they know for sure that she's lying, has a job to do. And if she wants to testify, it's her right to do so.
It is her right to do so, and this is an exciting case to follow. We are carefully monitoring it, but as you know, here on Law&Crime, that's not the only case that we're focused on, because we are going to be live today in the Roy Oliver case out of Texas, and that's what I want to talk about right now. This officer was on trial for the murder of 15-year-old Jordan Edwards. There's really the only place to start is from the body cam footage from Officer Gross, which captures the moments that this officer fired his rifle into that car packed with teenagers. He will claim that he felt that that car was a threat to his partner. He will say that he didn't know if anybody in that car was a shooter. Well, you be the judge yourself. We're going to play that body cam footage right now. Take a look. It's always pretty incredible to see an officer fire his weapon in a situation, but here we have to ask, was this a reasonable use of force? I want to bring back in Jonna Spilbor to talk more about it. Jonna, his defense attorney, Bob Gill, told the jury in the opening statement that the law requires them to view that situation through Oliver's perspective. Right. Is that a correct analysis of the law?
Well, yes, it is, because what Oliver had to have acted reasonably. So in order to determine whether he acted reasonably, you have to know, you kind of have to get inside his head. So you look at that scene. Now, initially, if you just looked at that scene with nothing else, it hurts the defense because the car's not coming at them. The car is actually backing away. So physically, the officer is wrong. But he also took the stand in this case. And unlike the defendant in Shayna's case, the other case we're covering, he did help himself, I believe, with his testimony, because he allowed the jurors to get inside his head. The thing that struck me the most is that he said his partner was the one screaming, "Stop the car, stop the car." In his mind, he thought that the partner was in danger because he was hell-bent on stopping that car. Therefore, he thought the shooter was in that car, and that's why he opened fire.
And that may be the case, but he has acknowledged what a terrible mistake he ultimately made, because Jordan Edwards and nobody in that car had any weapons. They had nothing to do with the shooting. And none of them, there was no alcohol or anything like that. We'll take a quick break, and when we come back, there's a lot more to discuss. Okay, so that was some of the testimony from one of the good friends of Jordan Edwards, who was there that night, and he gets emotional on the stand. Obviously, it's very difficult to imagine what he was going through and what he's going through now thinking about this. I want to bring back in Jonna Spilbor to ask a quick question.
Yeah.
We have seen Oliver testify that if someone, whether somebody, a bystander, would have said, hey, I know there were gunshots, it's nobody in that car, they sped away, because nobody in Jordan Edwards' car, including Maxwell Everett, was the gunman. If somebody would have told him, then he would never have taken his rifle out and he never would have fired. But is it really the responsibility of other people outside to tell him what was going on? It's
absolutely not the responsibility of innocent bystanders to tell him what's going on. And I can't imagine that's actually true. I think the most important thing that was going on in this officer's head was listening to his partner make commands of this car and the car not listening to him. I think that's much more crucial than the officer claiming that if a bystander had told me differently, I would have acted differently. Right, but it is something to say because we're trying to understand why this happened. We obviously know who did the shooting. We know how it happened, but it's pretty incredible. Now, I'm told I think we have to go to a quick break. We do. So when we come back, hopefully we'll either be live in Oliver or we'll talk more about it. We'll be right back after this. Okay, that was a big statement. In his mind, looking at that video, the car was not a danger. The car already passed Officer Gross. I'm here with Jonna Spilbor to break it down from a legal perspective. So, how is the defense going to argue away from the guy whose very job is to analyze frame from frame of that video and say, hey, that car already passed Officer Gross? Yeah, I don't know how well they can do that on the cross-examination of this expert, but I do think they can do it pretty well and did do it pretty well when they were examining their own client, the defendant in this case. Because again, what really struck me, when we covered this last week, I said to myself, this guy's dead going to bed. But when I heard his testimony and I heard him say, my partner was the one screaming, stop the car, stop the car. I can understand how an officer thought that the partner knew something that he didn't know. The partner wanted that car stopped. The car started to move away. He got out his gun and he shot. That makes this officer a little bit more human than it made him for me last week when we were covering this case.
But at the end of the day, all that matters is really the perspective, the reasonable man's perspective of Officer Oliver. Was it reasonable what he did? And that's what John and I are going to talk about. But it is important to listen to the testimony of Philip Hayden. He is a use of force expert that was brought forward by the prosecution. Let's hear what he had to say about whether or not Officer Oliver shooting his rifle into that car full of teenagers was a reasonable use of force. I know I'm kind of leading it, but you'll see yourself. Take a look. That's one of the state's experts saying that there was no reasonable, justifiable use of force in this case, and that is a big statement to make and really will hurt the defense's case. Not to mention what the update that we just got in court right now. The defense, the judge is allowing the lesser included charge of manslaughter. That means that jury will be able to find either murder or manslaughter or not guilty. Jonna, that's a really big hit for the defense, correct?
It is, because I'm going to go out on a limb. This case is about manslaughter. This was reckless conduct by a police officer. It wasn't intentional murder. Now the jury has a second attempt to get a conviction on something less. That's probably what they'll do.
Yeah, because they either were going to get not guilty by self-defense. We'll take a quick break on our end. We'll be right back. Stay tuned. Okay, so that's the defense going over a series of objections with the judge over the proposed jury instructions. The jury instructions are critical in every case, but particularly this case when you have to define what self-defense is, what a reasonable belief is. And what was also interesting about our live feed is you saw the prosecutors going over to the family and friends of Jordan Edwards, shaking their hands, acknowledging them. This has been a really long case, a really long ordeal, and clearly they want justice in this matter. Want to bring back on, Jonna Spilbor to talk more about this. Jonna, let's talk about what happened here. Big day for the state. The fact that they can now include manslaughter, and not just, it's not just murder versus not guilty by self-defense, but now manslaughter. The defense was objecting strenuously at that, and they didn't get it. They didn't get it. And so now the jury can find for manslaughter here. You know,
I don't blame the defense for objecting to that. They should have objected to that. Look, there was one lane that this prosecution was in the entire time, and that lane was, this is murder. They even brought up, and I told you during the break, this was unusual. They brought in an expert to determine whether the use of force was reasonable or not. In a criminal case, that is weird. It would happen in a civil case, and I suspect that when this family does sue civilly, and they will, they'll probably bring in the same expert that the prosecution used. But now the jury doesn't have to do all or nothing. Now the jury has a middle road to choose from. And if you think about it, that may be appropriate, but I'd be upset if I were the defense camp in this case.
You said civilly. Do you say, you mean the family could sue the police department?
Yep, for wrongful death.
And what is the likelihood that that would be a successful outcome? So it doesn't matter what happens here in this case, right? So how would it work like that?
So it's not going to be dependent on that, but typically when you sue a police agency for wrongful death, it does help if there is a criminal conviction against that officer, because it makes life a whole lot easier. You're probably going to see a settlement of some sort. But that's exactly the type of expert, the use of force expert is exactly what you would see in the civil context, more so than in the criminal context.
You know, as we're concluding this case, we're coming down to the closing arguments, and after our break, we're going to go back live into the courtroom. We might have those. The judge is still working on those jury instructions. Do you think the defense put on a strong enough case? Why didn't they call their own use of force expert who could say, you know what, his use of force was reasonable?
I don't think the defense needed to turn this into a battle of the experts because it is a criminal case. And the defense did put on the defendant, who did a pretty good job of explaining why he did what he did. It swayed me, and I'm a diehard. It swayed me, so I think that's what they chose the defendant over an expert.
When you can move Jonna on different sides,
you can move a mountain. Yes,
that's a big statement. All right, everybody. Here's what we're going to do. We are going to take a break on our end, and when we come back, we are going to go live and talk more about the Roy Oliver case. You don't want to miss it. It's coming to a conclusion. Stay tuned. We'll be right back. The defendant himself taking the stand. Good move, bad move? Well, we have to see. Let's bring back in Jonna Spilbor. Jonna, as we wait for the live feed back in the Roy Oliver case, there's so much to talk about. So as I said, I stand corrected. There was a defense expert that was brought in to say that the use of force was reasonable. The state brought out their own expert who said it's not reasonable. How on earth is a jury supposed to figure this out when two experts are saying two different things?
Well, as what often happens in a civil case, competing experts, quote, cancel each other out, right? Because sometimes the jury's going to say, well, one said the prosecution paid one to say one thing and the defense can't pay one to say another thing. So who are you supposed to believe? So when they cancel each other out, the jury typically relies on other testimony. And I have to continue to go back to the defendant's own testimony because, number one, he had to take the stand in this. We predicted this last week. He had to do it so that the jury could get inside his mind and determine whether his actions are reasonable. And I think he did himself a favor. Okay. I think he is explaining what was going on good.
I'm going to ask you the million-dollar question. You're probably going to hate me for this. You ready?
I could never do that. Go
What
ahead.
is reasonable? What is reasonable? We have one person saying not reasonable. We have another. The jury has to figure that out. The judge is trying to work on jury instructions about what reasonable belief is. What does Jonna Spilbor say reasonable is?
Reasonable is basically a person of average intelligence, common sense, right? So every jury there, you're going to have to imagine they're of average intelligence. And I don't mean that in a bad way. I mean that, you know, we're not talking about
the standard.
Yeah, standard. They're going to apply their common sense in a similar situation. And this isn't a reasonable person standard. It's a reasonable officer standard, right? It isn't every day that you and I are marching into a house with guns, right? We don't do that on a typical day. Officers do, well, sometimes, right, and occasionally a Wednesday.
Right.
But officers do. So this officer did a good job of matching up the facts as he knew them. My partner was screaming, stop the car was not stopping, gunshots are being fired. What's a police officer to do? I think he's doing well, and that is a reasonable police officer standard.
That was very good. That was an amazing law school analysis right there of what reasonable is.
Law school was a long time ago, Jesse.
Well, not that long. Now, here's the deal. Hopefully, the jury instructions were as clear as Jonna just made them to be, because now we have a good sense of what reasonable is, but the jury needs a good sense of what reasonable is, because a man's life is on the line. We'll be right back after this. Okay, so that's the defendant himself explaining what happened that night, and it is important because we are coming to the conclusion of this saga. We are expecting the closing arguments by both the state and the defense as soon as we come back from our next break. Now, I want to talk with Jonna Spilbor about this. I'm going to start off with the state. What do they need to do in their closing argument? And remember, now they have the option of murder or manslaughter, the lesser included.
So listen, I actually think that's a little bit of a problem for the prosecution, and here's why. They were in one lane this entire time, and they made point after point after point, and their lane was this was murder. Now, all of a sudden, after the defendant took the stand, judge, we might now want an instruction for something less than murder, manslaughter. Now, in their closing argument, they have to explain to the jury why they changed lanes. I mean, are they still going to say this is murder, this is murder, this is murder, but let me slide you this manslaughter instruction? I think the defense is in a much better position at this point because they're in one lane. They've been in that lane from the beginning, and they're going to stick in that lane. That this killing was excusable as self-defense, and one of the final things the jury heard was the defendant's own testimony, and I think that's going to play a big part in their decision-making.
Interesting perspective about that. The jury sees right through what the prosecution's doing, but what does the defense ultimately need to say? I know we have about 20 seconds left. What do they ultimately need to really hit the biggest point?
You may not like it, but this killing was excusable. This was a reasonable police officer acting in a reasonable manner, ladies and gentlemen of the jury. Everyone's sad that this young man is dead, but you have to excuse this conduct.
Jonna, thank you so much for coming on. As always, I appreciate it.
Thank you.
All right, we're going to go to a break, but when we come back, we will hear the conclusion of this case. Stay tuned here on Law and Crime.